Okay, so good evening everyone. Welcome to today's lecture on climate change litigation and the climate case of Friends of the Earth Netherlands against Royal Dutch Shell. I am Liao Xuxia, assistant professor at Peking Law School, and I am a professor, I am a teacher in public international law. Today we are very honored to have invited Professor Otto Spijkers to give this lecture. Professor Otto Spijkers is Professor of International Law at Wuhan University's China Institute of Boundary and Ocean Studies, as well as its Research Institute of Environmental Law. And he is also a founding staff member of its International Water Law Academy. He is managing editor of the Chinese Journal of Environmental Law. Prior to joining Wuhan University, he worked at the Utrecht University and Utrecht Center for Waters, Oceans, and Sustainability Law and the Netherlands Institute for the Law of the Sea of Utrecht University. He was visiting lecturer at various institutions, including here at Peking Law School and the Xiamen University's China International Water Law Program. He wrote his doctoral dissertation entitled The United Nations, the Evolution of Global Values and International Law at the Grosser Center for International Legal Studies of Leiden University. Today we are also very pleased to have three discussants with us. And this is Dr. Yang Xin. She is a postdoc researcher at the Kaiyuan Law School of Shanghai Jiaotong University. Her research focuses on comparative environmental law research between China and the United States. And this is Professor Wu Kaijie, assistant professor on environmental law at Peking Law School. And here's Mr. Tang Ke. He's a PhD student at CUPL, and his thesis dissertation is about climate litigation. I believe that our panelists will bring in today's event a unique perspective with their experience and expertise. So for our event today, Otto will give us a lecture for about 40 minutes. Thereafter, Dr. Yang, Dr. Wu, and Mr. Tang will make comments for about 5 to 10 minutes. After that, the floor will be open for questions from the audience. Okay. So, Otto, you have the floor.
Yeah, thanks very much. Actually, we have met in Utrecht, where she was a guest researcher for a while. So we were both at the Netherlands Institute for the Law of the Sea. And now we see each other again here in Peking, so it's a very small world, I think. Of course, it's a really great privilege and an honor for me to address you. As the chair already mentioned, I'm now a professor at Wuhan University, so another great university in this lovely country. And as you can see on the slide, Wuhan is most famous for its cherry blossom. So every year around April, May, lots of people, they come to our campus to take photos of the cherry blossom and usually of themselves as well. So they take selfies. So that is what we are famous for. So let me now get started. I will time myself, I guess. So 40 minutes. Just a second. Okay. Yeah. So I will be basically discussing climate litigation, but since I'm from the Netherlands, I will mostly focus on climate litigation European style. And that basically means using international human rights law as the legal foundation for climate litigation. And I understand that climate litigation in China may use a different legal basis, and that is also why I'm so pleased to have Ke Tang as one of the discussants, because his expertise is climate litigation in China, of which I know very little, so I'm really looking forward to his contribution. So my presentation reflects critically on the actual and potential influence of Western-style climate litigation on the who should do what question in managing climate change risks. So who has to bear the burden for climate change? Who is responsible, and so on. And I believe that the Netherlands is a particularly interesting case study, not only because I am from the Netherlands, but also because legal proceedings have been initiated there, first against the state of the Netherlands itself, and then also against a huge global oil company, Shell, which happened to be headquarters in the Netherlands, in the city of The Hague. So a foundation called Urgenda initiated proceedings against my state, the Netherlands, and this was then followed by Milieudefensie, that's Friends of the Earth Netherlands, initiating proceedings against this multinational oil corporation, Shell. So the Urgenda proceedings have already closed, and the Shell proceedings have only just begun, with a district level ruling on 26th of May 2021, and the case is currently on appeal. So Shell has appealed the decision of the district court. Before I turn to the discussion of the two cases, I wanted to briefly clarify the meaning of some of the basic terms that I will use in my presentation. So you see them on the slide. So what are climate change risks? Well, in the future, the climate will be significantly warmer than it has been in the past. And extreme weather events, heat waves, storms, droughts, forest fires, floods, heavy rains, and so on, they will all occur more frequently and will be more severe than in the past. And also the sea levels will rise, and we will experience a continuing loss of fragile ecosystems and biodiversity, especially in the marine environment. And so, as some of you know, currently we are negotiating a new treaty to protect biodiversity in marine areas beyond any state's national jurisdiction. But due to Corona, this has been delayed a little bit. Anyway, climate change risks. So these and other negative consequences of climate change will make it very difficult for various actors to shoulder their ordinary responsibilities in the future. For example, energy providers may not be able to provide enough energy due to a drastic increase in the demand for electric cooling, like CV installations. And hospitals may not be able to treat all their patients due to an increase in illnesses caused by heat waves, and particularly the elderly are vulnerable to these kinds of illnesses. And farmers may not be able to provide enough food to feed the entire population because their fields will be negatively impacted by the droughts and the floods and water scarcity. And rising sea levels also cause intrusion of salt water into the fresh water, and making groundwater impossible to use to irrigate your crops. So on. So climate change risks are those risks to the ongoing integrity and functionality of natural and human systems because of climate change. So to prepare for these new situations, various actors have to sort of reconsider their ordinary business activities and try to think of ways to cope with this new situation. And most people, they will look to the government and expect the government to develop some kind of climate change policy with a reasonable allocation of responsibility for managing climate change risks. So they will expect states and maybe also multinational corporations to a lesser extent to carry most of the burden. In other words, and I'm now going to be a little bit controversial, people like you and me are reluctant to make significant changes to their own daily lives if this affects their current standard of living in a negative way. We all want the government to take care of climate change, not us. So this in turn results in a reluctance, especially of democratic governments, to impose drastic measures because that will make them unpopular. I guess this problem is less acute in China than in my own country, because if my government is too aggressive in combating climate change, then it is guaranteed to lose the next election, so they can't do that. And to break this stalemate, courts can jump in and play the role of a catalyst. So that brings me to climate litigation. So what does that mean? When courts oblige states and multinational corporations like Shell to take their responsibility, they do so through climate litigation. And in my presentation, I want to look at 2 examples. So climate litigation is a type of public interest litigation. And what does that mean? Well, it refers to a situation in which a non-governmental organization, an NGO, initiates a case, not in its own particular interest, but in the general interest, so in the interest of society as a whole. That could be a state's entire population's interest, but it could also be the interests of both the present and the future generations of the entire world. So the interest could be vast and enormous. And public interest litigation is most often used against a government, and in the context of climate change, most people indeed first look to the government as the actor with the primary responsibility to lead the way and tell us how to adapt our way of life to this new situation. But climate litigation can also be targeted at a non-state actor like Shell. So my presentation will focus on the Western style climate litigation, and that basically means human rights-based climate litigation. So in other parts of the world, including China, the legal basis of climate litigation might not be human rights law. It could be something else, and that's perfectly possible. This is just, it depends on your tradition. But both cases I will discuss have made use of the human rights framework, and especially that of the European Convention on Human Rights. So the claimants in both cases argue that dangerous climate change constitutes a threat to life. That's Article 2 of the European Convention on Human Rights, and constitutes a threat to people's right to enjoy a healthy environment. And that is derived from Article 8. And the state and corporations like Shell then have a duty of care, a due diligence obligation, or an obligation of conduct, not of result, to protect or at least not to endanger the enjoyment of these rights for the people within their control, jurisdiction and control. So that's not the same as your people. For example, I am now in China, and that means I'm now under the human rights jurisdiction of the Chinese government. So it's not the Netherlands government that has to protect my human rights, it's the Chinese government that has to do so. Now that I'm in China, so within Chinese jurisdiction. And if you guys come to the Netherlands, then it's the Netherlands government that has to protect you from threats to your life and healthy environment and so on. That's how human rights law works. So the argument is quite simple. If climate change continues, then some of its most drastic consequences, like rising sea levels, droughts, floods, rising temperatures, and so on, they will actually constitute a very threat to the life of the population. And the state has a duty to protect people's rights to life and to a healthy environment. So if the government does not do enough to protect our lives from the dangerous effects of climate change, it is acting in breach of the European Convention on Human Rights. So let me now turn to the first case. That is the Urgenda case. It's named after this foundation that initiated the case. So this Urgenda case is probably still the best known example of this Western style climate litigation. It has received a lot of attention in the scholarly literature, and it has inspired people and foundations all over the world, but especially in Europe, to initiate similar proceedings in their jurisdictions. So what was the Urgenda case about? Well, it was a case initiated by a foundation called Urgenda, established under Dutch private or civil law, directed against the state of the Netherlands. So Urgenda held the Netherlands responsible for not doing enough to prevent dangerous climate change and or mitigate the harmful effects of climate change. And it qualified this inaction as a breach of the duty of care, as it exists under Dutch tort law. So that is really important to let this sink in. So basically, it was a breach of Dutch tort law. But it was also a breach of Articles 2, the right to life, and 8, right to a healthy environment of the European Convention on Human Rights. So following the earlier rulings of the Dutch District Court in 2015, Appeals Court in 2018, the Supreme Court of the Netherlands sort of confirmed and ruled also in Urgenda's favor on 20 December 2019. So the District Court in 2015 relied mostly on the Dutch law duty of care argument, but the appellate courts and the Supreme Court, they emphasized more on this human rights argument. So the argument based on an alleged breach of Articles 2 and 8 of the European Convention on Human Rights. So on the slide here you see the legal team of Urgenda, and they are very emotional because they didn't really expect to win. So when they won, they were like the lead counsel, he was actually crying when he was interviewed immediately after he heard the judgment. So nobody really expected Urgenda to win. And then they did win, not only at district court level, but also at appeals court level and also at Supreme Court level. So each time they beat the Netherlands, the government. And now, as an aside, so now, of course, the Netherlands has to comply with this ruling. So they have to change the Netherlands climate change policy, making it much more ambitious. And, I guess this will not come as a big surprise. The Netherlands government is not doing a particularly good job. So basically, they are not complying with this ruling. And that is becoming more and more obvious. So it might very well be that Urgenda at some point will go back to the court and claim, well, they're not complying, so we want them to pay a certain amount of money for each month that they continue to refuse to comply. That's how Dutch tort law works. So let me now turn to the other case. That's the case that was initiated by Milieudefensie, Friends of the Earth Netherlands, against this global oil company Shell, headquartered in the city of The Hague, Netherlands, which also happens to be my hometown. So on the 26th of May 2021, the district court in The Hague delivered its judgment in this case. And again, the court agreed with the claimants that Royal Dutch Shell, that is the company that's operating globally, is doing too little to reduce greenhouse gas emissions and to prevent serious climate change. And serious climate change, in the view of the court, is already a global warming of over 1.5 degrees Celsius. And it's it's a certainty that we will at least experience this warming, but probably it will get much warmer than that. In view of the court, Royal Dutch Shell is thereby acting unlawful, and it must significantly reduce its greenhouse gas emissions and bring them in line with the global climate objective of primarily the Paris Agreement. So there's a lot of references in the court's ruling to the Paris Agreement. So more specifically, the court ordered Royal Dutch Shell, both directly and via its companies and legal entities with which it forms this Shell group, to limit or cause to be limited the aggregate annual volume of all greenhouse gas emissions into the atmosphere due to the business operations and sold energy carrying products of the Shell group, to such an extent that this volume will have reduced by at least 45% net at the end of 2030 relative to 2019 levels, 2090 levels. I find this an extremely complicated sentence, so instead of memorizing it, I always just read it out, because I always get lost halfway through the sentence. But basically it means Shell must drastically reduce its greenhouse gas emissions. So interesting for us lawyers is that there is a crucial difference between the Urgenda litigation and the Shell litigation, and that is that the former is targeting a state, state of the Netherlands, and the latter is targeting a non-state actor, that's an oil company, Shell. So in the Shell case, the court made clear that the claimants could not directly invoke Articles 2 and 8 of the European Convention on Human Rights with respect to Shell, because that's a very simple fact. Human rights only apply in the relationship between the state and the individuals residing within that state's jurisdiction. And to put it in even more simple terms, Shell is not a party to the European Convention on Human Rights, for obvious reasons that only states can become a party. So Shell is not legally obliged in any way to comply with this convention in a sort of direct sense. But the court, so the court did acknowledge this, the court is not stupid. But then the court did believe that it is appropriate to factor in the human rights and the values these rights embody in the court's interpretation of what is required of Shell to meet this duty of care as it exists in, under Dutch domestic tort law. So this is a bit complicated. So this duty of care is basically a sort of a standard of behavior that is not written anywhere. You don't find it in any act or statute or treaty, but it's just a sort of unwritten minimum standards of behavior, what is sort of socially accepted of states or companies. And to fill in this unwritten standards of behavior, you can look to treaties and non-legally binding documents and so on to figure out what we could reasonably expect from a company like Shell. So the court also referred extensively to the UN guiding principles on business and human rights. That's the so-called Ruggie principles, which talk about the responsibilities of multinational corporations. But those are also not binding, not legally binding. So the court used them in the same way as the European Convention on Human Rights. So none of these instruments are binding on Shell, but they do sort of enlighten us or give us further information as to what we can reasonably believe to accept of Shell. And the court made an interesting distinction between different kinds of obligations, and it distinguished between scope 1, scope 2, and scope 3. This may be a little bit too detailed, but I do find that an interesting part of the ruling. So basically the court distinguished between Shell's own greenhouse gas emissions. So those are emissions from Shell's own factories, oil producing factories. And then there's scope 2, those are emissions of companies that Shell uses for its activities, such as an energy company that can provide energy to a Shell factory. Like companies that provide immediate services to Shell. That's scope 2. And then scope 3, that's maybe the most interesting one. Those are emissions of the users or the consumers of Shell's products. And that's a vast category because that's basically everybody in the world that drives a car. So if you ever tank at a Shell petrol station, you are a consumer of Shell's products, so you fall within this scope 3. And a lot of commentators were a bit puzzled about this part of the court's judgment. So how can Shell be expected to change the behavior of every single person in the world that is using Shell's petrol? How are they supposed to do that? And Shell itself was also openly posing this question, like, how can we be asked to motivate every single car driver in the world to improve its behavior and maybe buy an electric car or not drive so much, or I don't know, when it goes to the nearest supermarket, maybe they can take the bicycle. But how is Shell supposed to motivate people to maybe not take their car, but then choose the bicycle instead? So yeah, that's a bit puzzling to many people, including Shell. But, okay, what sort of nuances this problematic a little bit is that only with respect to Scope 1 emissions, so Shell's own emissions, does Shell have an obligation of result. But with respect to Scope 2 and Scope 3 emissions, Shell only has an obligation of conduct. So Shell has to do its very best to persuade us, the consumers of its products, to live a better life. But if they fail, okay, it's not Shell's fault. At least they tried. It's an obligation of conduct. They have to make a serious effort to try. And yeah, very interestingly, so very shortly after this ruling was issued, on Dutch television, you see a lot of commercials produced by Shell that actually encourage people to drive more responsibly. It's very interesting. And also more drastic policy choices have been made. So shortly after this ruling, Shell actually sold its shares or interest in the biggest oil field in the United States, the Permian Basin in Texas. And Shell sold these interests for $9.5 billion, so there's a lot of money involved here. Of course, Shell will never acknowledge that they sold their interests because they were told by this little judge in this little town in The Hague. Yeah? So they say, we always planned to do this. But it is kind of remarkable that they have sold these interests not so long after the ruling was made. So I think we can assume that there is at least some causal link there. But I do want to say that let us not rejoice in the fact that a big bad oil company lost a case against the heroes of the earth, the friends of the earth, Netherlands. That would be too simplistic, because we actually do rely, all of us, we do rely a lot on Shell. So this is me in Xi'an, in China, in June of this year. I was visiting a friend there, and then I happened to see that even in Xi'an we have a Shell petrol service station. I was very surprised. So this Dutch company is also active in China. It's basically active everywhere in the world. And the services it provides to us, we like them a lot. So now to say that Shell is the bad guy that is destroying our planet, maybe that's not entirely fair. Yeah, I have about 20 minutes maybe. So in the time that remains, I wanted to look briefly at some of the most often used defenses or counter-arguments that states and other oil companies use when they are accused of not doing enough to protect the right to life and to a healthy environment. So in this climate litigation, what are the counter-arguments that the bad guys, the states and the oil companies put forward? I find that very interesting. And the first one is the drop in the ocean argument. Here you see a drop in the ocean. The second one is the waterbed argument. So I will address that next. Then there's the scientific uncertainty argument. And then the fourth is the sort of the fourth argument is the we must act, but maybe not today, maybe tomorrow argument. You hear that very often. So I begin with the first one, the drop in the ocean argument. So they're both quite simple, actually. I'm often very puzzled by this. So Shell and also the state of the Netherlands, they hire this big group of extremely well-paid lawyers to defend their interests. But then the arguments they come up with, they are so simple. I think anyone could have come up with them. So the drop in the ocean argument is one of the first. So this argument basically makes the point that the contribution of one single state or one single company to causing climate change is so small that it's actually negligible. i.e. it is a mere drop in the ocean. And of course, this argument is a little bit difficult to make when you are defending a huge country like China. But if you defend the Netherlands, I think you can make this argument that actually the greenhouse gas emitted from the Netherlands is quite small. So if only the Netherlands would stop emitting greenhouse gases, but the rest of the world would just continue as usual, yeah, that wouldn't make any difference. So that's the argument. So why do we have to do all this and others not? That's the drop in the ocean argument. But for a huge oil company like Shell, it's already a bit difficult to make this argument because their contribution to climate change is quite big. Well, the counter-argument, of course the court was not convinced by this argument. So the counter-argument is that, of course, climate change is a global phenomenon. But individual states or corporations, they cannot escape from their responsibility by arguing that their adaptation or mitigation activities will only have a negligible impact, the drop in the ocean. Quite the opposite. Each state and each corporation must shoulder its part of this globally shared responsibility to prevent dangerous climate change. And I want to quote from the Urgenda judgment because I think they put it very well. So this is the quote, I'm now quoting. The defense that a state does not have to take responsibility because other countries do not comply with their partial responsibility cannot be accepted. Nor can the assertion that a country's own share in global greenhouse gas emissions is very small, and that reducing emissions from one's own territory makes little difference on a global scale, be accepted as a defense. Indeed, acceptance of these defenses would mean that a country could easily evade its partial responsibility by pointing out other countries or its own small share. If, on the other hand, this defense is ruled out, each country can be effectively called to account for its share of emissions, and the chance of all countries actually making their contribution will be the greatest. End of quote. I mean, this is a very common problem in law and in philosophy, that it's sort of this problem of the collective, that we are all responsible for something, and the consequence of that is that individuals do not really feel a individual responsibility. They say the world should do something about this, but not me, and maybe you, but not me. Yeah. So it's a very common problem. And this argument is often countered with a sort of ad absurdum argumentation, and Shell was indeed making this kind of argument. And then it's argued that if the government is now holding Shell and the Netherlands responsible for causing climate change, then shouldn't I be starting a case against my neighbor because she takes a too long shower? Isn't that also a contribution to destroying the world? So shouldn't I start legal proceedings against my neighbor for showering too long? So you hear a lot of these arguments being made, that if we accept this kind of proceedings, then where does it stop? But then the court said, no, the contribution to climate change must not be absolutely negligible. So you cannot sue your neighbor for causing climate change by showering too long, but you can hold a huge oil company like Shell or a state like the Netherlands responsible, because their contribution to climate change may not be huge, but it's not negligible. So there is a limit. And then the waterbed argument. So this is a waterbed. So this is a reference to the so-called carbon leakage problem, according to which companies will escape from the Netherlands to states with less strict greenhouse gas reduction obligations or less activist courts. And that, so the argument goes, will only relocate the problem and not solve it. Like water in a waterbed, it moves to the place where the least pressure is put on it. So if the Netherlands puts a lot of pressure on oil companies, they will just go somewhere else. and move their headquarters to a country that is not so strict on them. I find it very interesting that Shell already announced almost immediately after the ruling was issued that they are not going to move their headquarters from The Hague, Netherlands. They have no such plans. I thought that was very remarkable that they very clearly and very strongly made this statement. Because that does actually solve a lot of problems. If you move your headquarters somewhere else where there's not such activist courts, then you will not be subjected to further climate litigation. Another argument that we hear from Shell a lot is the one that it is unfair if Shell must comply with these very strict Dutch court rulings, but competing oil companies headquartered elsewhere in the world cannot be subjected to such climate litigation. So Shell made this argument that if it stops producing fuel from oil, some other oil company will simply step in and will be just as polluting and emitting just as much greenhouse gas as Shell does. And the first reaction of Shell to the ruling of the Dutch court was indeed a LinkedIn message posted by its chief executive officer, Bert van Beurden, in which he made this argument. So I'm going to read from the slides. So this is a LinkedIn message. To mention one perhaps extreme scenario, imagine Shell decided to stop selling petrol and diesel today. So that would certainly cut Shell's carbon emissions, but it would not help the world one bit, because demand for fuel would not change. People would fill up their cars, and they will still, and delivery trucks at other service stations. So Shell acknowledges that society needs to take urgent action on climate change, but a court ordering one energy company to reduce its emissions and the emissions of its customers is not the answer. And he believes Shell should work with customers and their sectors to help find their own pathways to achieve net zero emissions and so on. Yeah? So if everybody is attacking Shell, then maybe Shell will be forced to sell all the interests it has in oil fields, but it will sell these interests to some other oil company, and then the problem is not solved. That's a very an argument that you hear very often. But the court was not convinced by this argument. A bit same reason as the drop in the ocean argument. Hey, you have to start somewhere. And the court was sort of hoping that other oil companies, like British Petroleum, would be held similarly responsible under their jurisdictions. And you do see that other jurisdictions, like the UK, are following suit. Okay, now I'm going to be a little bit cynical, but I do want to share this with you. So this was a message on LinkedIn, and on LinkedIn you can comment on other people's messages. So one comment that Ben van Beurden received was this one, from the chief executive of British Petroleum, the UK oil company, so Bernard Looney. He said, "Great message, Ben. It's clear to us at British Petroleum just how committed you and the Shell team are and have been to the energy transition. It's an enormous challenge, so all the more reason for us to continue to work together where we can to help the world get to net zero." I don't know. I find it very hard to suppress my tendency to share with you some sarcastic remarks on this comment. So it's basically one CEO of one oil company congratulating the other on its fine achievements. Okay, I'm not going to comment. So actually the way major oil companies communicate about climate change like this was researched by a team at Harvard University. I'm sure you have heard of this university in the US. Geoffrey Supran and Naomi Oreskes, they actually published a report today, as we speak today. And in this research they concluded that some oil companies, they use the same subtle, systematic propaganda techniques that major tobacco companies have been using in the past to shape public opinion on climate change. So what does that mean? They attempt to shift a responsibility away from the company to the consumer. And this is a very good, very clear example of that. So it's the emissions of the consumers we have to focus on. I mean, Ben van Beurden is literally saying that. So they attempt to shift responsibility away from the company to the consumer, that's us, ordinary people. So we have to change our behavior and then Shell will follow suit. It's not the other way around. We have to change. And at the same time, they present fossil fuel companies as innovative, trustworthy, and essential companies. We cannot do without them, and basically they are part of the solution, not part of the problem. So this kind of rhetoric, according to those researchers at Harvard University, is basically copied from the major tobacco companies, because they made very similar arguments. They're telling their customers, well, if you guys all stop smoking, we will no longer produce cigarettes. Think about it. Yeah, and then the scientific uncertainty argument. So both the Netherlands and Shell, they've pointed out that there is scientific uncertainty about the exact consequence of climate change. So they're not denying climate change. Netherlands not denying it, Shell is not denying. In fact, Shell has been aware of climate change since the late 1980s, when they did their own research about this phenomenon. But as the appeals court had already noted in the Urgenda case, in the late 2010s, there's enough scientific certainty already to conclude that there's a real threat of dangerous climate change, which is likely to constitute a risk even to the lives of the present generation of the Dutch citizens. So it's not about our children or our children's children. It's about us. We already experience the negative consequence of climate change. And, well, of course you hear this less and less often, this argument that is made, well, we were not sure if climate change really exists, and even if it does, well, it might also have some positive consequences. I mean, the Netherlands, it will be warmer and more comfortable. We don't have to go to the south of France to enjoy the sun. We can just stay in the Netherlands and so on. You hear those arguments a lot, but actually you hear them less and less because we are starting to really experience the negative consequence of climate change. So it becomes harder and harder to deny this phenomenon. And in such circumstances, Articles 2 and 8 of the European Convention on Human Rights do create for the state a duty to protect. And in case of uncertainty, the precautionary principle also always tells us to err on the side of caution. So if we are not sure, the precautionary principle tells us, well, maybe not take the risk. And then finally, I think I have about 1 or 2 minutes. The last excuse is of course we have to do something about climate change, but maybe not today, maybe we can do it tomorrow. So in reply to this argument, which also you hear quite a lot, this delaying tactic, the Supreme Court in the Urgenda case emphasized that the duty to protect us, to protect our lives, to protect our right to a healthy environment, encompasses risks that may materialize in the longer term, possibly only after a few decades from now on. So on Article 2, on the right to life, the Supreme Court in the Urgenda case noted, and I'm going to quote, the State of the Netherlands is obliged to take appropriate steps if there is a real and immediate risk to persons and the state in question is aware of that risk. In this context, the term real immediate risk must be understood to refer to a risk that is both genuine and imminent, but the term imminent or immediate does not refer to imminence in the sense that the risk must materialize within a short period of time, but rather that the risk in question is directly threatening the persons involved. So the protection of Article 2, European Convention on Human Rights, that's the right to life, also regards risks that may only materialize in the longer term. So our lives may not be threatened today, but action, or rather inaction today, will actually cause us to die in 20 years from now. So the court further noted that, and I quote again, the obligation to take appropriate steps pursuant to these human rights provisions also encompasses the duty of the state to take preventive measures to counter the danger, even if the materialization of that danger is uncertain. And that is consistent with the precautionary principle that I referred to earlier. So those are the 4 excuses that I wanted to share with you and that you hear all the time. And the court in the Netherlands did not find them very persuasive, and neither do I, but I'm curious what you think. So that's why in the end Shell lost and the state of the Netherlands lost their case. And they now have to quite seriously reconsider some of their policies. But you actually see that Shell and Urgenda are doing so that's a good positive sign, positive development to end my lecture with. I thank you for your kind attention.